this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're in session number 8 of our ongoing series related to the Division of Workers' Compensation's recent discipline and denial of renewal applications of hundreds and hundreds and hundreds of qualified medical evaluators. And I remember telling you in session 5 several weeks ago that I was amazed that this discussion even required 5 sessions. Well, we then went on to require session 6, session 7, and new information has come forward and forth that compels me to speak with you again, and that brings us today to session number 8. Now, to set the stage for today's discussion, I want to refresh your memory that in our last session, session 7, we talked about the Division of Workers' Compensation's new online educational video for qualified medical evaluators, wherein we learned for the first time the DWC's new interpretation of the complexity factors under CCR 9795. And in that video, the DWC shows us how we are to bill our reports according to their new interpretation, specifically as relates to the ML104 billing level. And in our last session, I presented to you an actual case report that was on my own desk. It was a case that I had recently evaluated myself, and I subjected that report to the new billing constraints which are demanded by the Division of Workers' Compensation, and I demonstrated to you how those new billing constraints reduced the value of that report over $2,500 because the time involved and the billing involved with report preparation under the ML104 is now being disallowed by the Division of Workers' Compensation, except in very tight circumstances which require a written request from the parties in advance of the evaluation that the evaluation involves extraordinary circumstances. So in that actual case report, or case of a report that I shared with you, the value of the report was reduced by over 60% because the time involved with report preparation, which was over 10 hours, had to be written off the report based on the DWC's new interpretation. So what I want to talk to you today about has to do with how you will bill your ML104 reports from here on out. And let me just ask you in a rhetoric question, now that you know the Division of Workers' Compensation's new fist-tight interpretation of causation as a complexity factor, and now that you know about the Division of Workers' Compensation tight-fisted interpretation of report preparation under ML104, how will you bill your reports from now on? How does this new interpretation change your QME practice? How does this new interpretation change the time that you invest in evaluating injured workers? Well, there are some signs of good news coming. As you know, this very week, on December 7th, the Division of Workers' Compensation is going to be called into court in Los Angeles County, where they are going to be required to explain their drastic actions of non-certifying over 400 qualified medical evaluators for supposed allegations of improper billing through misuse of the complexity factors. Well, in the weeks preceding this upcoming trial, many parties have come forth in support of doctors and in opposition to the Division of Workers' Compensation. And one of those parties, which I shared with you several sessions ago, is Sue Honor Vangarov, who was one of the authors of the Medical Legal Fee Schedule. She's opposing the Division of Workers' Compensation. And most recently, another party has come forward to oppose the Division of Workers' Compensation. and that is the California Society of Industrial Medicine and Surgery, also known as CSIMS. And in the past couple weeks, CSIMS has become increasingly vocal in their opposition to the DWC. So both of these parties, Sue Honor Vangarov and CSIMS, provide excellent support through regulation, through labor codes, and through the historic evolution of the medical legal fee schedule to support proper billing as it's always been done by qualified medical evaluators up until 2016, when the Division of Workers' Compensation instituted this so-called new interpretation. So the Division of Workers' Compensation is going to have some explaining to do, and it better be good, this coming week in Los Angeles County. But in the meantime, until we get some resolution on this, let me ask you, how will you bill your medical legal reports? Will you continue to bill your reports the same way you always have? Or will you defer to the Division of Workers' Compensation and reduce the billing of your medical legal 104 reports by writing off your report preparation time? Will you reduce the value of your report 60% in those ML104 cases? And even further, will you invoke causation as a complexity factor from here on forward in those circumstances where you are evaluating a claim that may not qualify for the DWC's new interpretation of causation, which requires that the evaluation involve a denied claim? How will you bill your reports from here on out? So I want to talk to you about those two things, the report preparation under ML104 and the causation complexity factor. So let me start by saying that it's my opinion that both of those new restrictions that are being imposed by the Division of Workers' Compensation, they're going to disappear. They're going to disappear, and things will go back to the way that we've always known them. That's my projection, and that's what I anticipate will happen. The reason I anticipate that is because the Division of Workers' Compensation's new interpretation make absolutely no sense. They make absolutely no sense based on the exact language that's presented in CCR 9795, and also they make no sense related to real world application of the actual cases that we evaluate. And let me just give you some examples on that, and I'll share some examples on that with you, especially as relates to causation. So I believe that both of those tight restrictions are going to disappear. Well, just last week we get a recommendation from CSIMS by way of an email blast advising us to go ahead and bill for report preparation time in those cases that involve an ML104, a bona fide ML104, even when you do not have a written request from the parties in advance of the evaluation that the evaluation involves extraordinary circumstances. CSIMS is telling us, go ahead and bill for report preparation time. Let me ask you, do you dare do it? Do you dare oppose the DWC when you know that the DWC has recently stripped over 400 QMEs and put over 400 QMEs through hell in trying to get back their QME credential? Do you dare oppose the DWC, or do you feel that it's safer to just comply with the DWC? Well, the decision on that ultimately remains your own, but let me read to you what CSIMS had to say in an email just last week. They talk about first how CSIMS has opposed the DWC and how they've done it very eloquently, and they provide several references of documentations that the CSIMS has submitted both to the Division of Workers' Compensation and also to the court in Los Angeles for this week's hearing. So they provide support for their opinions and conclusions. And they tell us in this email, they say that the administrative director of the DWC continues to support reimbursement of report preparation time through IBR, independent billing reviews of ML104 reports. So under independent bill review, report preparation time continues to be reimbursed. And CSIMS considers this evidence that report preparation time is to be reimbursed. And the reimbursement of report preparation time is supported by the administrative director. They say, why is this important? They say it's important because CSIMS believes that the current enforcement of underground interpretations should not intimidate QMEs and AMEs who know the regulation and who bill properly. So, are you intimidated? I know I'm intimidated. I'm intimidated to bill for my report preparation time. I'm intimidated that the Division of Workers' Compensation could deny my renewal application. I'm intimidated that the Division of Workers' Compensation could order me to pay restitution for overbilling of my reports. Yes, I'm intimidated. Are you intimidated? Well, CSIMS advises that we should not be intimidated. They say that the key is to be very familiar with the terms and definitions of the current medical legal fee schedule, and that is CCR 9795. So, with regards to report preparation time, I said I believe that this restriction is going to go away. CSIMS apparently believes that it's going to go away as well, and CSIMS is advising us to go ahead and bill for the report preparation time. Do you dare do it? What about causation as a complexity factor? As you know, the Division of Workers' Compensation is now denying causation as a complexity factor in every single case that involves an accepted claim. According to the Division of Workers' Compensation's new interpretation, causation is never an issue. Never. Causation is never an issue when the claim has been accepted. Causation can only be an issue when the claim involves a denied claim. This is the Division of Workers' the DWC's current interpretation. Well, CSIM says, with regard to causation, remember, or no, they say, with regard to causation, understand that many claims involve multiple injuries, some of which may be admitted and some denied. While it is inappropriate to discuss the causation of an admitted injury, it is quite necessary and proper to discuss the causation of a disputed injury, whether primary or consequential. So, based on this, do you dare bill causation as a complexity factor in those cases that involve an accepted claim? Do you dare? I'm not sure what to advise you, but it's my opinion that even the causation restriction is going to go away because it makes no sense in the real world wherein we practice and wherein we evaluate injured workers who always continually present with a barrage of issues related to industrial causation. And I'll share one such case with you. So CSIMS advises us that claims can involve issues of causation even when those claims have been accepted. So that's interesting because in the lawsuit that's being presented this week in Los Angeles County, the attorneys involved with defending the QMEs give some position regarding causation as a complexity factor, and they oppose the DWC's interpretation. They say that the DWC's new and different criteria for the application of the medical causation complexity billing are also contrary to reality. And here they give an example contrary to reality. They say, for example, it's well established that an employer may accept an injury as industrially caused because the employee complains of back and leg pain after lifting something heavy. So the employer accepts the claim. But when the QME interviews the injured worker and takes a full medical history, the QME may determine that the injured worker actually injured himself a week earlier, sliding into home plate during a recreational softball game unrelated to work. The QME may then decide that the back and leg injuries are more consistent with the non-industrial sliding injury than with the industrial lifting injury. Medical causation on an industrial basis may then be refuted. The DWC's changes to the written text of the causation complexity factor thus fail a reality check against real-world facts and circumstances. So the attorneys for the QMEs provide an example as to how causation and a discussion of causation can be required even in those circumstances that involve an accepted case. Well, that position is reiterated in the declaration of Sue Honor Vangerov, also citing causation as a complexity factor. She says, upon written request of one of the parties, the QME addresses medical causation because an accepted claim may turn into a denied claim once a QME obtains a full medical history from the injured worker. She says, this is why medical causation can be used as an ML104 complexity factor. The DWC's additional rules for medical causation constitute what is known as void and unlawful underground regulations under case law and the Administrative Procedures Act. So, two authoritative sources have come forward to oppose the Division of Workers' Compensation's position on report preparation and causation as a complexity factor. So for the balance of today's discussion, I want to talk to you about causation. Now I know we've talked about causation until it seems like there's nothing more to be said about causation. And that's not true because issues continue to unfold regarding causation. So what I want to share with you today is another example from my own case files. For a case that I'm currently working on. Last time I shared with you the billing reduction on a case I'm currently working on. Today I want to share with you some causation examples from a case I'm currently working on. So in other words, I say that because I want you to know that I did not have to dig through the archives of files to come up with these examples. These are everyday current examples. And I'm sure that you have these issues on your desk right now as well. But the case I want to share with you now, the purpose of reviewing this case with you is to provide another example to the Division of Workers' Compensation as to how causation is a flowing issue. It's not just a black or white, accepted, denied issue. Causation is a multifaceted and multifactorial issue that's in constant evolution, and it's always an issue. And the parties have the right to request, and the QME has the right to discuss, and the QME has the right to be paid for causation as a complexity factor upon request of the parties. The parties have the authority to ask for a discussion of causation and in all of its phases and all of its form at any time along the life of the claim, not just at the inception of the claim, which is the DWC's position, that causation can only be discussed at the inception of the claim, which fails a real-world reality check, according to Sue Honor Vangerov and according to the attorneys in Los Angeles. Well, I have an example for you of a case that involves difficult and ongoing issues of medical causation, wherein causation remains a complexity factor throughout the life of the claim. So in this case, I want you to know that I first evaluated this case long before this controversy with the DWC arose. And when I saw this examinee for the first time, the claim had been accepted. I saw the examinee more than a year after the date of injury. In fact, it was more like 18 months. The examinee had already received medical treatment. They'd already received over 6 months of total temporary disability. The claim was accepted. Okay, do you follow? And yet, the parties, through written request, asked for a discussion of causation because they wanted an updated opinion from a new person, which is the qualified medical evaluator, new guy on the case, right? New guy coming in on the case. They wanted to know, what's the QME's position on causation? So the written request says, please conduct your usual comprehensive exam and furnish the parties with a narrative report setting forth your findings. We would appreciate it if you would address in your report the following question. And question number 3 says, whether or not the medical findings are consistent with the original injury claimed by the employee over 18 months ago, and they give the date. They ask for a discussion of causation. The next question says, if disability exists, remember disability is need for medical care or work modifications, either work restrictions or total temporary disability. It says if disability exists, is it industrially caused or aggravated? So by written request in an accepted claim, 18 months after the claim is accepted, the parties are requesting a discussion of causation. Now, according to Mr. West, or according to the Division of Workers' Compensation, in this circumstance, because the case is accepted, the discussion of causation, no matter how complex it may be, does not qualify as a complexity factor under the new interpretation. Well, this evaluation was more than 2 years ago, and of course I employed causation as a complexity factor and had my report paid completely, 100%, with no fee reduction. It was an ML104 report. The causation as a complexity factor was paid. Time involved with report preparation was paid. Okay? Now, fast forward about a year later, and the parties asked me to reevaluate the injured worker. Now, by now, more than 2 years, actually about 28 months have passed since the date of injury. The claim has been accepted, benefits have been providing, treatment is ongoing, and they asked me to reevaluate the examinee. Now, this is more than 1 year after the first evaluation. So this report, this reevaluation, does not qualify as an ML101 because ML101 requires that the reevaluation take place within 9 months. Well, this was more than 12 months after the first evaluation. How do you build this report? Well, I build it as an ML104. And it's interesting because by request of the parties, new issues of medical causation have arisen in the case. And how often does that happen? That's ubiquitous. That happens all the time. New issues of medical causation are the rule, not the exception. Do you understand Division of Workers' Compensation? New issues related to causation extend beyond the AOE-COE determination. New issues with causation are the rule and not the exception. Let me give you an example. The parties request a couple things. First of all, the parties provide some instruction to the qualified medical evaluator here on page 1 of the report. The instructions are, number 1, please read entire cover letter prior to examination. Number 2 says, please respond to all questions in this cover letter. So what they're asking is, would you please give us the answers to the questions in the cover letter? So here's some of the questions. Number 2, it says, regarding causation. Hasn't causation already been established? Why, the claim has been accepted. It's not a denied claim. Why would issues of causation be requested more than 2 years after the date of injury? Well, as I said, issues with causation are evolving and ever developing throughout the life of the claim. And this evaluation perfectly illustrates that. It says, regarding causation, it says, specific issues to be addressed in the comprehensive medical report. And it goes on from question number 2, which is a causation question, and I'll read it to you. The causation discussion that they're requesting goes to the end of the page and continues on to page 3 down to this point. So these continue with causation questions. And let me just read some of them to you. Did the applicant sustain an industrial-related injury either as a result of a specific injury, comma, continuous trauma, or both? On what basis did you reach this determination? Question mark. Please thoroughly address the following in your report. And here they list 1, 2, 3, 4, 5, 6 issues related to causation. Is the mechanism of injury anatomically or ergonomically consistent and verifiable, or is the injury description vague and implausible? Have other possible causes, such as pre-existing conditions, family history, or prior injuries of the condition been properly considered and ruled out? Do the symptoms and affected body parts follow an accepted and well-defined clinical pattern? Are there risk factors for potential symptom magnification, somatization, or malingering? Is the patient's presentation, and on and on and on the questions go. And then in a separate section, a new grouping of questions here says, if work-relatedness is established, is the etiology deemed original injury, reoccurrence, aggravation of a pre-existing condition, or an exacerbation? A complex discussion of causation is necessary in order to respond to these questions, which are demanded on page 1, wherein the parties say, please respond to all questions in this cover letter. Now, should this qualify as causation as a complexity factor? The case has been accepted. According to the Division of Workers' Compensation, there would be no reimbursement for causation as a complexity factor because the case has been accepted, even though the parties are asking for some complex medical decision making from the doctor to consider all these new circumstances by written request of the parties. So that evaluation took place 12 months after the first evaluation. I billed ML104. I billed for report preparation time. I invoked causation as a complexity factor. It was paid completely. Now, according to the Division of Workers' Compensation, I should not have billed for either of those. Well, time went on, and we arrived in 2017, and by this time, the examinee has now become represented. There's now another party involved with the case. Well, they took my deposition, and in deposition, several new issues arose. guess what those issues were related to? They were related, of course, to causation. So the parties agreed that another reevaluation would be necessary. Now listen to this. Here's a letter from the applicant attorney. The applicant has alleged an injury to the neck, back, spine, left shoulder, and left upper extremity on a cumulative trauma basis from 1/1/2014 and a cumulative trauma through June 1, 2016. We took your deposition, and as a result, we have scheduled a reevaluation for you to see the injured worker. Please make sure to address all body parts that have been alleged. And there's a new allegation, which was revealed to me at the deposition, that the examinee was claiming a back injury. Prior, it was cervical spine and left upper extremity. Now the back and spine have been added to the claim, and then also 2 periods of cumulative trauma, in addition to the specific incident of injury, were added to the claim. And isn't this how cases go? The cases are constantly evolving, morphing into more and more issues, most of which revolve around causation. Why should causation be limited to those cases that simply involve a decision for or against AOE-COE? It shouldn't be. In fact, the language of the law does not limit causation to only accepted versus denied claims. That's not in the language of the law. The language of the law tells us that causation applies as a complexity factor when we have a written request from the parties. That's all the law requires. Now, since this reevaluation, well, let me read to you what the defendant asked. So I gave you what the applicant asked. And by the way, this third reevaluation was more than 12 months after the second reevaluation. So this report cannot be billed as an ML101 for a reevaluation because it took place more than 9 months after. So I'll tell you how I billed it in just a sec. So here's the defense attorney's cover letter. The defense attorney cites now new dates of injury to include the cumulative trauma periods. So I'm going to be asked to address whether or not there were cumulative trauma injuries. The defense attorney states, oh, this is great. The applicant has returned to you at this time for final reporting. The applicant was deposed on April 15, and at that time disclosed a motor vehicle accident in March of 2016, which was before the date of the second reevaluation. Motor vehicle accident came before the second reevaluation, but she made no mention of it in the reevaluation. It wasn't addressed at the reevaluation because there was no knowledge of it, but new knowledge came of it later. She disclosed a motor vehicle accident. Physical therapy was prescribed by her primary treater. She continues to work full-time for a subsequent employer. A subsequent employer. She now has a new employer different from the employer involved at the time of injury. Do you think there's going to be issues involved with the subsequent employer, such as perhaps a cumulative trauma claim with the subsequent employer? In fact, the claims administrator was concerned that why would this examinee continue to have symptoms? She's no longer with us. She's with a different employer. So the claims administrator wanted to file a CT claim against the new employer. New issues of medical causation. It says, this claim has been denied. It says, please carefully review your prior reporting and confirm your earlier opinions on impairment and apportionment and address causation for the claimed low back portion of the claim. Do new issues of causation continue to develop throughout the life of a claim? Of course they do. Of course causation as a complexity factor applies anywhere along the life of the claim as long as there's a written request from the parties. So the cover letter asks, are the medical findings consistent with the original incident of injuries as reported by the applicant? That's a causation question, correct? It says, did the applicant sustain an industrial injury? If so, was this a specific injury or a continuous trauma? If the injury was due to a continuous trauma, during what period did the injury occur? Questions, questions, questions regarding causation. For this evaluation, I build ML104, including causation and including report preparation time, and it was paid 100%.